Welcome to the 7th Cambridge Arbitration Days. I feel like I'm saying welcome to Jurassic Park when I say that. I'm Mel Schwing. This is my co-convener, Alina. I'm not going to pronounce her last name because I mess it up every time. But I've been asked to give these welcome remarks this morning after Alina gave hers yesterday. And to be honest, I was supposed to write something up. But then this morning, as people came in, and I wanted to say hi to Dr. Leanne O'Leary, Ian Gaunt, Miff Wood, I didn't get a chance to. And then I realized that was the point. Because one of the goals we had when we put together this Cambridge Arbitration Day was that we had been locked up for 2 years in a pandemic. We had been and seen virtual presentations by different arbitral organizations where learned people spoke on the screen about arbitration. And we thought about possibly doing that this year to be safe. I will say, and Alina's going to groan when I say this, that another academic institution that's based in Cambridge, in my homeland, that I affectionately call the Stanford of the East, chose to do their arbitral day virtually this week. But we decided to do ours in person because of those interactions, because of the chance to have coffee, have pastries, have drinks, to get to know people, because it's the people that are behind arbitration. We wanted to make sure that people got a chance to see everybody, to talk to people, to get them know them. That's the point of these conferences. It's as much as the presentations, which I've seen the previews, it's outstanding. But at the end of the day, it's about the people. And we are here today, and it's been a difficult ride. I'm not going to say it hasn't been. We've had some people come down with COVID. We've had to substitute speakers at the last minute. We've had to twist some arms here at the faculty to make sure we got certain facilities open. But we've had wonderful support from so many people, and that's why we're here today. We've had an unbelievable list of sponsors. Our gold sponsor, CANDEY. Our silver sponsors, Clifford Chance, Arnold Porter, Pinheiro Neto from Brazil, the London Maritime Arbitrators Association. We've had bronze sponsors, Altenberger, Three Crowns, Jade. We have receptions being sponsored by DLA and Ashurst, and Altenberger and Jade. We have had so much support. And I've also had the support of a wonderful organizing committee of LLM students here at Cambridge. And we are thrilled to be able to welcome you here today in person for this event. I could go on and on about the people who have been here and people who have supported us and how much work Alina's done. But I think you've all come here to hear these outstanding panelists lined up here. So I'm gonna stop and just start the program, unless you have something more to say.
No, I'll quickly move on to introduce the amazing moderator of this panel, Miff Wood, who is a partner at Ashurst and actually a graduate and scholar of the University of Cambridge, where she completed her LLM as well. So Miff, as I said, is a partner in the international arbitration team at Ashurst with a broad practice and particular expertise in global energy and resources disputes, including oil and gas, renewables, clean energy, mining, and African-related disputes. She also has experience in other markets, including Asia, the Middle East, Europe, and Australia. Miff represents a range of global clients and is successful in running large, high-value, and technically complex disputes. She advises in relation to commercial arbitration, investor-state arbitration, other cross-border disputes, including litigation and public international law. She has also experience in class actions. She's a co-chair of the Young International Arbitration Group of the LCIA and a founding member of the Working Group on Legal Tech Adoption in International Arbitration, which recently adopted this protocol for online case management in international arbitration. Miff also sits on the case analysis panel for arbitration with LexisNexis and is listed as a rising star in 2019 Legal 500 arbitration power lists and in the 2020 and 2021 Legal 500 rankings. So I'll give the floor to her, who will moderate this panel in and introduce the rest of our speakers today. Thank you all for being here, sincerely, and I personally look forward to hearing from you. Thank you.
Okay. Thank you so much to the organising committee for having us today and for organising an in-person conference in circumstances which are perhaps less than easy to do so. So well done. It is an absolute pleasure to be here. I had kind of cold sweats walking into this lecture theatre, wondering what readings I haven't done, whether someone was going to ask me to provide my opinion on a particular case that I didn't read because I was drinking or growing. So it's very nice to actually be sat down here. Now, it's a great pleasure to be moderating such an esteemed panel. I think we're incredibly lucky to have this panel today. The topic for discussion today is investment treaty arbitration, and our panellists are each going to be speaking in relation to particular trends in international treaty arbitration, investment treaty arbitration. So I'm joined by Kate Cervantes-Knox, who is a partner at DLA Piper. So Kate is a solicitor advocate, and she has over 20 years' experience of representing clients in commercial arbitrations and investment treaty disputes across a range of sectors. And she has a real focus on energy and infrastructure disputes. Now, Kate has been recognised as a global leader by Who's Who Legal and by the Legal 500 and Chambers for her experience in the field of commercial arbitration, investor-state arbitration and public international law. Kate also sits as an arbitrator and is a fellow of the Chartered Institute of Arbitrators, and she's currently president of the LCIA European Users Council and a director of the board of the LCIA and a member of the ICC Arbitration and ADR Commission. So it's an absolute pleasure to have Kate with us. Next to Kate, we have Belinda McRae. Now, Belinda is a barrister at 20 Essex, and she has particular specialisation in private international law, public international law, and international arbitration. She also appears both as sole counsel and junior counsel on international arbitrations under a variety of institutional rules. Belinda's also been appointed as sole arbitrator and wing arbitrator on a range of international commercial cases and is ranked in the Legal 500 and Chambers as a leading junior in international arbitration. Now, before coming to the bar, Belinda was at Freshfields in Paris. So you can imagine she did an array of fantastic international arbitration and public international law, and she has also worked in international courts and tribunals in Cambodia, Tanzania and Australia. And she's also an alumni of Cambridge, doing her LLM in 2010. So we're very lucky to have Belinda with us as well. Next to Belinda is Alvaro. Alvaro focuses his practice in international investment law and public international law. He is counsel at Arnold Porter, and he has represented sovereign states and commercial entities in numerous arbitrations governed by ICSID, PCA, SCC, UNCITRAL, and the ICC rules. He's also advised clients on nearly a dozen ICJ proceedings and multiple other international disputes litigated before the ICC, the Inter-American Court of Human Rights, and a range of UN bodies and national courts of various states. So if you're studying PIL, I suggest you go and speak to Alvaro after this. He's a lecturer at Queen Mary University in London, where he co-teaches an LLM on international dispute resolution. And he's also a visiting lecturer at King's College London, where he teaches a course on oceans governance and has taught PIL and investment law at other leading universities. And finally, we have Lionel Nichols, who's a partner at CANDEY, the gold sponsor here today. Another Australian. That's a very Australian-heavy panel today. Lionel is a partner and barrister, and he specialises in public international law, investment treaty arbitration, international arbitration and human rights. He has 15 years' experience advising states, corporations and individuals, and has appeared on a wide variety of international, regional and domestic courts and tribunals. and he holds 3 master's degrees and a PhD in law, and is a fellow of the Chartered Institute of Arbitrators. And he also sits as an arbitrator. So, without further ado, I'm going to pass on to Kate, who is going to talk to us today about the Achema line of authorities and the impact that has had on intra-EU investment treaty arbitration. Over to you, Kate.
Thank you very much, Miff, and good morning, everybody. Thank you very much to the organising committee for inviting me to come and speak today on this absolutely fascinating topic. It's probably one of the most important developments in investor-state arbitration in recent years, the decision of Achema, the subsequent decisions of Komstroy and PL Holdings, and I'm going to be looking at those decisions and how they impact on intra-EU investment arbitration and indeed in EU investment in general. Achema is a decision that scarcely needs introduction for those involved in the field of investor-state arbitration. This game-changing decision of the Court of Justice of the European Union has had far-reaching ramifications for intra-EU investor-state arbitration. Together with these subsequent decisions that I'll be looking at today, it has dramatically altered the landscape of intra-EU investment arbitration and the protections available to investors within the EU. Indeed, I would say that Achema actually marked the beginning of the end for investor-state arbitration in the EU, and it's left a chasm as far as the protections for investments in this region are concerned. Its impact on investment within the EU is yet to be seen. So first, let's look at the key findings in Achema. The decision was given in the context of an unstructural arbitration brought by Achema, a Dutch insurance company, against the state of Slovakia, pursuant to the bilateral investment treaty between the Netherlands and Slovakia. Under that treaty, Slovakia had agreed to offer protections to investments made in its territory by Dutch investors, and, importantly, to arbitrate any disputes which arose under the treaty. The arbitral tribunal found that Slovakia had breached the treaty and they awarded damages in favour of Achema. However, Slovakia commenced proceedings to set aside the award in Frankfurt, which was the court of the seat, because this particular case wasn't an ICSID arbitration. It was UNCITRAL and it had a seat in the EU in Germany. And Slovakia argued that their accession to the EU had removed the jurisdiction of the arbitral tribunal provided for in the BIT, and that the arbitration agreement was contrary to the Treaty on the Functioning of the European Union. The German Court of Appeal decided to refer this issue to the Court of Justice of the European Union and to seek a clarification as to whether the arbitration agreement in this investment treaty did in fact conflict with EU law. In its landmark decision in this case, the Court of Justice of the European Union held that the investment arbitration clause contained in BITs between EU member states, such as Article 8 of the Slovakia-Netherlands BIT, are indeed incompatible with EU law and therefore invalid. In arriving at that conclusion, the Court of Justice referred to the key EU principle of the autonomy of EU law, enshrined in Article 344 of the Treaty on the Functioning of the European Union, and the preliminary ruling procedure provided for in Article 267 of the Treaty, which ensures the uniform interpretation of EU law. Contrary to these provisions of the EU Treaty, Article 8 of the Slovakia-Netherlands BIT was found to confer jurisdiction over disputes which may relate to the interpretation of EU law on an arbitral tribunal which is not part of the EU judicial system. This was found to call into question the principle of mutual trust between member states and the preservation of EU law. Effectively, it was not open to EU member states to agree to remove intra-EU investor-state disputes from the system of judicial remedies prescribed by EU law. So just pausing there, Achema had the potential to invalidate all arbitration agreements in bilateral investment treaties between EU member states, of which there were many. One of the key advantages of bilateral investment treaties is that very arbitration provision, which is found in the treaties and allows investors to bring an arbitration claim directly against the state before an independent arbitral tribunal. So as you can imagine, this decision caused shockwaves in the investment arbitration community. It was widely criticised, and because it had the potential to not only invalidate the arbitration agreements in these treaties, but it also had the ability to invalidate the awards rendered in the many ongoing arbitration proceedings between parties under these intra-EU BITs, and to make those awards unenforceable. So this had dramatic and chaotic consequences. It's perhaps unsurprising that arbitral tribunals constituted pursuant to intra-EU BITs consistently refused to be bound by the ruling of the Court of Justice of the European Union, and they found various ways to distinguish their cases from the decision in Achema. As pointed out by several arbitral tribunals, in reaching its decision in Achema, the Court of Justice didn't consider the provisions of the Vienna Convention on the Law of Treaties and failed to engage with the clear conflict between that treaty on the law of treaties and the EU treaty and the way that the Court of Justice had construed the EU treaty. And in fact, the Court of Justice implicitly resolved this conflict between the two treaties entirely in favour of EU law. And they failed to analyse the requirement in the Vienna Convention for treaties to be interpreted in accordance with the rules of that convention. So that was one sort of very fundamental way in which the decision was criticised, but there were other ways in which it was distinguished. In Micula in Romania, the tribunal found that the circumstances giving rise to the dispute in that case occurred prior to the relevant member state's accession to the EU. In Raiffeisen Bank in Croatia, the tribunal found that Achema postdated the registration of the investors' dispute. And in Musnianka Polka in Slovakia, the tribunal found that the BIT and the EU treaties don't share the same subject matter, and so there is no incompatibility. Tribunals also found that the Achema decision didn't apply to arbitration claims brought under the Energy Charter Treaty, which is a multilateral investment treaty regulating investments in the energy sector, to which EU states are a party, and also contains an arbitration provision. Tribunals seized with disputes under the ECT found that, first of all, the Achema decision didn't say anything about the ECT, and so couldn't possibly impact on their jurisdiction. Also, they noted that the Council of Europe itself is a party to the ECT and had agreed to be bound by the arbitration agreement in it. Tribunals also found that the plain language of Article 26, interpreted in order to give its ordinary meaning in accordance with Article 31 of the Vienna Convention, did not carve out intra-EU disputes. There was no distinction being drawn in that arbitration agreement between disputes between parties to member states and disputes between parties who are not EU parties. So, how did the member states react to Achema? Well, there was universal rejection by Achema by investment arbitration tribunals, but the member states, in fact, embraced the Achema decision and, of course, started to routinely raise the Achema jurisdiction objection, as it became known, in pending arbitrations. And then, on the 5th of May 2020, came a further and even more devastating blow to intra-EU investment arbitration. A plurilateral treaty was signed by 23 of the 27 EU member states, terminating their intra-EU BITs. This termination treaty operated not only to terminate the bilateral investment treaties applicable between the member states, but also purported to end all investment arbitrations currently pending under intra-EU BITs. So investors were then left with the options, according to the terms of this treaty, with entering into a structured dialogue with the host state, or bringing a claim before their domestic courts, neither being options which many investors would take great comfort from. And then along comes Moldova and Komstroy. This is a further case of the European Court of Justice. In this case, in which my partner in the DLA Paris office, Michael Ostrov, was lead counsel, representing the Republic of Moldova, the Court of Justice not only confirmed its findings in Achema, but it went even further. And it found that the arbitration clause under Article 26 of the Energy Charter Treaty does not apply in the case of intra-EU investment disputes under the ECT. So effectively, the Court of Justice arrived at exactly the opposite conclusion as all of these arbitral tribunals that had looked at this question previously. So now Achema has been extended from intra-EU BITs, which now, in any event, have been terminated, to the multilateral ECT. What's most extraordinary about the Court of Justice's decision in the Moldova case on this particular issue is that neither of the parties to the dispute were from the European Union. They were from Moldova and the Ukraine. So you might be forgiven for wondering what on earth this case has to do with the European Union and the Court of Justice of the EU. Moreover, the question which had actually been referred to the Court of Justice was a preliminary ruling sought by the Paris Court of Appeal on the question of the proper interpretation of the definition of investment in the ECT. So they were not seeking a ruling on the applicability of the arbitration agreement to EU parties, as you would expect, because neither of them were EU parties. However, while the court recognised that it didn't have jurisdiction to interpret an international agreement as regards its application in a dispute between an investor of a non-member state and another non-member state, the court decided that where a provision of an international agreement can apply both to situations falling within the scope of EU law and to situations not covered by that law, it is clearly in the interest of the European Union that, in order to forestall future differences of interpretation, that provisions should be interpreted uniformly, whatever the circumstances in which it's to apply. So the Court of Justice decided that even though it wasn't an issue relevant in this case, they were going to decide this important issue of whether the arbitration agreement in the ECT bound member states. Their decision is highly problematic because the ECT is a multilateral treaty to which also non-EU states are a party. And commentators have argued that Article 26 of the ECT cannot have different meanings for the EU member states that are parties to the ECT and the other ECT parties that are not EU members. Indeed, as the tribunal in Urquisol in Italy found, if the intention of the drafters of the ECT was to have such an effect, they would have included a disconnection clause. And the fact that they didn't do so indicates that they didn't intend to create a different regime for EU member state to EU member state disputes. Nonetheless, the Court of Justice decision in Komstroy establishes that Article 26 of the ECT cannot be invoked in intra-EU investment disputes, putting at risk the awards in proceedings already commenced under Article 26 of the ECT. Now, hot on the tracks of Komstroy, the Court of Justice delivered yet another decision on the 26th of October 2021 in the case of Poland and PL Holdings, which was the nail in the coffin for intra-EU investment disputes. This decision demonstrated that any creative arguments which might serve to circumvent Achema would surely fail. In that case, the Svea Court in Sweden, being the court of the seat of arbitration, had dismissed Poland's set-aside action based on the Achema objection on grounds that the investor and the host state had freely concluded an ad hoc arbitration agreement in the same terms as Article 9 of the Poland-Belgium BIT, and that this agreement was enforceable. Poland appealed before the Supreme Court of Sweden, which then referred the issue to the Court of Justice for a preliminary ruling. The Court of Justice roundly rejected this ad hoc arbitration solution to the Achema problem, which the Swedish court had accepted, It found that member states cannot circumvent their obligations under the EU treaties by concluding an ad hoc agreement identical to an arbitration agreement in an international agreement between member states, which is contrary to EU law. So that loophole was firmly closed by this decision. It's noteworthy that the arbitral tribunal had found that PL Holdings had not only had their investment expropriated in breach of the treaty, it had also suffered a denial of justice before the Polish courts. But nonetheless, the Court of Justice stated that PL Holdings' rights must be protected within the framework of the Polish courts, and found that even if there is a lacuna in the Polish court system, this cannot justify a failure to comply with principles of EU law. So effectively, the court was saying that PL Holdings had to go to the very courts which had denied it justice already to seek justice. So where do these developments leave intra-EU investments? Well, I'm afraid they leave us with a slightly or very bleak outlook for intra-EU investment arbitration going forward. First, the Achema and subsequent decisions mean, in effect, that an award made in any non-ICSID arbitration commenced pursuant to an intra-EU BIT is at risk. This is because if the arbitration is seated in the EU, the courts of the seat are obliged to apply Achema when seized with a set-aside application or when asked to enforce an award. So investors who have successfully brought non-ICSID claims under inter-EU BITs, even before Achema was decided, will almost certainly have their awards annulled or be unable to enforce them, at least within the EU. Can you imagine being an investor who's spent millions and millions of pounds going through years of investment arbitration to obtain an award which now is subject to annulment or can't be enforced? This is a pretty dramatic result for investors who've invested within the EU. Arguably, ICSID awards made under intra-EU BITs are less vulnerable because ICSID awards are in their own framework under the ICSID Convention, and they don't have a seat of arbitration. So they're not subject to the overview of the European courts or the domestic courts of the seat. However, if the investor needs to enforce their ICSID award in Europe, then again, Achema rears its head at that stage. So in view of these consequences of Achema, we can expect to see less ISDS arbitrations in Europe. We can expect parties to seek to enforce their awards outside of the EU, and we can expect investors to withdraw claims where these avenues are foreclosed. We can also expect to see investors structuring investments via countries outside of the EU so as to take advantage of extra EU BITs, which don't pose the same risks as the intra-EU BITs. Going forward, in view of the treaty terminating intra-EU BITs, we can say farewell to investment arbitration pursuant to those treaties, and for the time being, the investors will have to seek a structured dialogue or rely upon the local courts. As for the substantive protections which were contained in the intra-EU BITs, there is no indication of what, if any, protections will replace them. Investors might seek to enter into investment agreements with the host state, affording investment protections similar to those found in investment treaties. However, although in Achema the Court of Justice distinguished contract-based arbitrations from treaty-based arbitrations and found that contract-based arbitrations wouldn't be considered to contravene the EU treaties, it's unclear whether the Court of Justice will maintain that distinction for investment contracts entered into with member states. In theory, a private contract between an investor and a member state shouldn't offend the principles of mutual trust between member states under the EU treaties. However, in view of the PL Holdings decision, it's not inconceivable that the court may consider such investment contracts to be another attempt to circumvent Achema, akin to the ad hoc arbitration agreement in the case that was found to be invalid in that particular case. So in conclusion, what does the future hold for intra-EU investment? Well, it holds greater risk for investors, given the loss of protections previously offered by intra-EU BITs, less certainty as to the ability to obtain redress if investments are treated unfairly by host states. In the immediate term, plenty of annulment actions and attempts to resist enforcement in EU courts. Will all of this lead to less appetite for intra-EU investment? BITs were, after all, concluded by states in the belief that it would encourage investment in their states by offering these protections to investors. So now that these substantive and procedural protections have been taken away, can we expect to see less intra-EU investment, or will perhaps these increased risks be factored into the economics of such investments? Perhaps this will be the ultimate case study in whether the availability of investor-state arbitration is in fact correlated to the amount of investment in particular member states. But all of this remains to be seen. We'll surely see over the coming years the impact of all of this on investment. We will also see what's going to happen to the ECT, which is currently subject to reform discussions. There's been a referral to the Court of Justice already by Belgium to ask the Court of Justice to opine on whether the draft arbitration agreement in the new revised ECT offends EU law or not. So it's continuing to evolve this area, but certainly we've seen, as you will see from the cases I've just discussed today, we've seen some really quite dramatic developments in this field over the last few years. We'll continue to monitor their impact on investor-state arbitration. Thank you very much.
I propose that we have questions at the end so we can get to all of our speakers. So if you've got questions for Kate, write them down and then hopefully you can answer them after everyone's spoken. Our next speaker, Belinda, is going to speak to how English courts have dealt with jurisdictional challenges in the context of investment treaty arbitrations under Section 67 of the Arbitration Act. Thanks very much, Belinda.
Thanks very much, Miff, and thank you to Kate for that really interesting introduction to some of the issues that I'm going to look at as well. So I'm going to do the rather controversial thing of speaking at a panel about investment treaty arbitration and focusing on English court decisions. Now, this may not be what you came for, but I'm here to tell you it is what you should be listening to, because there are a number of important decisions which affect this area of law. So really one has the sense as a practitioner over the last few years that there is an increasing number of cases before the English courts that involve important questions of public international law. One has seen issues such as state and diplomatic immunity, the recognition of foreign heads of government and states, the content of customary international law, the relationship between the principles of self-determination and post-Brexit FTAs, all before the courts in the last 12 months or so. And a number of these issues have come before the courts because of investment treaty claims. So one way that this comes before the court is the commercial court's jurisdiction over arbitral claims. There's a wonderful part of the CPR, if you've never looked at it, Part 62, which deals exclusively with these kinds of issues. And what you'll see there is that these claims come primarily to the courts through the Arbitration Act 1996, with which you will all, I'm sure, be very familiar. In case you are not, there are two primary routes, just by way of introduction, by which a court might consider an investment treaty award. So first of all, you have the sort of challenges that I'm going to focus on today under Section 67 of the Arbitration Act, which deals with challenges to the jurisdiction of a tribunal. Sometimes as well, increasingly in the last few years, you have challenges under Section 68 of the Act. Now, this section deals with due process rights, what's known as challenges to the sort of serious irregularity of the award or the arbitral procedure. Indeed, there's been one investment treaty award that has been set aside partially on that ground, which is quite an interesting and novel development in this sort of sphere. The second is a challenge to the award through the process to which Kate referred of recognition and enforcement of the award. Now, this can happen through two sections of the Act, 66 or 101, depending on whether it's a foreign or domestic award or its enforcement under the New York Convention. So there are slightly different grounds that are worth bearing in mind. And one also has a particular system for ICSID awards. Again, this comes through a different act. It's a 1966 act, which is not very often used, but has come to prominence through the McCullough case, again, that Kate mentioned, and has gone all the way up to the Supreme Court. And these cases frequently involve fascinating issues of state immunity in particular, because a state might, having had an award against it and being faced with the process of recognition and enforcement, seek to say, well, there may have been an arbitration agreement, but that doesn't actually bite when one comes to recognition and enforcement, because, of course, the immunity that subsists in that regard is entirely separate. So very interesting line of case law. One that was just before the Commercial Court a few weeks ago was in the General Dynamics and Libya case, where the judge there, Mr. Justice Butcher, was considering the interaction between recognition and enforcement and state immunity. A further example, as Kate mentioned, is the PL Holdings case, again, also before the English courts. It's had a sort of rather extended journey through the Swedish courts, which remains ongoing, and the sort of European element. But again, there's an action to seek recognition and enforcement in England. And one might ask the question, well, why is this relevant now we have left the EU? To what extent does Achema actually apply in this jurisdiction for reasons, for example, of public policy, under New York Convention type enforcement arguments? And that question will be determined by the English court in the coming months. So I'm not going to talk about any of that, as interesting as it sounds. What I'm going to focus on is these jurisdiction challenges. And I'm really going to do it for two reasons. First of all, there have been three recent cases, two of which have proved quite controversial in investment arbitration circles because they have resulted in awards of tribunals being overturned. And the second thing, or second reason that leads me to draw them to your attention is that at least when I was an arbitration lawyer in a firm, I had no idea that there was this power under Section 67 for London-seated, or I should say English and Welsh-seated awards that could be overturned on jurisdictional grounds. And I think it's something that's really important to be aware of as arbitration students and practitioners. I suspect if you told the average investment treaty arbitrator that his or her award was susceptible to challenge on jurisdictional grounds in the investment treaty context, there might be some surprise or at least lack of familiarity with the process. So let me start with the basics. What is Section 67 and how might it be relevant if you have an investment treaty case? As I sort of indicated in outline a few moments ago, this section concerns challenges to the substantive jurisdiction of a tribunal. And it can arise in two ways. If you have a specific jurisdiction award and you wish to challenge it, that might be one route. But it also applies if the tribunal goes to a sort of full award on the merits, damages, etc., and you, as the unhappy party, might wish to argue that actually the tribunal had no jurisdiction whatsoever to go on to the merits. It's still an option in those circumstances. A really important feature of this particular jurisdiction is these challenges operate de novo. So what do I mean by that? When you come before the English court under Section 67, all the evidence and the arguments are up for grabs, generally speaking. So, for example, if you have a wonderful foreign law point as regards the construction of the relevant dispute resolution clause, you might be able to adduce expert evidence before the English court that you did not rely upon before the arbitral tribunal. And that means that the court will have quite different material and arguments before it, which can make a real difference. One thing as well that is notable is that unlike some of the other challenge mechanisms before the English court, you don't need permission. So you can go to the court as of right to challenge jurisdiction. This sounds, I think, particularly alarming to an international arbitration lawyer who has a wonderfully favourable jurisdiction award in his or her hands. But you'll be pleased to know there are some very significant limitations on the jurisdiction. Let me just outline some of those. So first of all, I mentioned it's substantive jurisdiction, and that has a particular meaning and manifestation within 2 sections of the Arbitration Act. It basically encompasses a few things. First of all, is there a valid arbitration agreement? And this is where some of the Achema issues can come in. Second, is the tribunal properly constituted? And third, which is the route that is most used in the investment treaty context, are the matters that have been submitted to arbitration within the scope of that agreement? Another thing to emphasise is that issues of admissibility, which you see often raised in the context of investment arbitration disputes, are not within the scope of the court's jurisdiction. There was a recent case in 2019, which has since been applied, that emphasises there is a clear distinction between jurisdiction and admissibility, which means that the court's power is limited to the former rather than the latter. Second, you must challenge an award rather than a procedural ruling or something like that. Third, you must also exhaust any available recourse under Section 57 of the Arbitration Act, which deals with clarification, and any sort of similar processes under the institutional rules. Now, fourth, this is an important thing. There is a very tight timeline of 28 days in which to get all your challenge documents up and running. So that's an arbitration claim form, witness evidence, a copy of the award, all the rest of it. You can try to apply for an extension of time, but it's typically very difficult to obtain. There are a few recent examples in commercial cases where that's been successful. The fifth thing that I would emphasise that has been the downfall in one recent investment-related case is that there is a provision in the Act that specifies that if a party knows of an objection on jurisdictional grounds but participates in the arbitration without raising it, then they can't later come to the court and say, oh, hold on a sec, actually we'd quite like to raise that point now. Effectively, that will operate as a waiver in respect to that party's ability to challenge. This barred one recent Section 67 application by the province of Balochistan in respect of a investment treaty type of case, where they sought to argue that, in fact, the underlying contract was void for reasons of corruption, and they were found to have waived their rights to bring that jurisdictional challenge for the purposes of Section 67. Sixth, and most importantly, because you might be getting quite excited about this rather broad jurisdiction, it only applies if you have an arbitration seated in England and Wales. Now, one might think that this doesn't really arise very often in investment treaty types of cases. I mean, think of ICSID and the way in which that framework works. But there is an increasing number, in my experience, of London-seated UNCITRAL or ICC-related investment treaty cases. So I think this really is an avenue to be aware of and to watch out for. When I acted in my first Section 67 case in this context back in 2016, which involved the Kyrgyz Republic, I think it was the 4th ever case to consider jurisdiction in this investment context. Since then, there have been a number of cases that have come before the court, and I'm going to look at 3 of them really briefly. 2 of them, as I indicated, resulted in the jurisdiction award of the tribunal being overturned. I want to consider the question, what regard do English courts pay to public international law and to the decisions of these eminent tribunals? The first case is a case called GPF and Poland. It was a decision of Mr. Justice Bryan, who incidentally was also involved in the Kyrgyz case I mentioned. It involved a claim under the Benelux Poland BIT relating to a series of acts that were occasioned against a Luxembourg company in respect of its real property investment. And they, it was alleged, culminated in an unfavourable decision of the Warsaw Court of Appeal. And the way in which it went before the tribunal was that the jurisdiction was limited to claims of expropriation only. And the tribunal gave two reasons for this. One, because it read the dispute resolution clause quite narrowly and said it excluded FET types of claims. And secondly, as a matter of international law, it barred the claim for what we affectionately call sort of creeping expropriation, saying that if you are relying on a series of acts that culminates in an event of direct expropriation, i.e. the taking of property rights by the Warsaw Court of Appeal, you can't really have creeping expropriation for the elements that came before. So these two things led to a very sort of narrow jurisdiction being asserted by the tribunal, which was led by Gabrielle Kaufmann-Kohler, David Williams QC, and Philippe Sands QC, so quite an impressive bunch. So what was, I think, the first reported case ever to take this step, the court parted ways with the tribunal and said, nope, you've got it wrong. In fact, there is broad jurisdiction and you should go back to square one and reconsider. Two key things. First, Mr. Justice Bryan disagreed as a matter of treaty interpretation with the tribunal's reading of the investment arbitration dispute resolution clause, in a reading with which I have some sympathy. And second, he found that, considering the principles of international law, they were wrong on the second point about creeping expropriation. Now, there are a few notable features of the cases of this case for our purposes. The judge gave a very detailed judgment of some closely typed 42 pages. In that judgment, he gave considered recourse to international law, both on sort of ICJ case law, arbitral tribunal decisions. It was really a rather careful, methodical, thorough consideration. It wasn't, as some might expect, a sort of English-based approach. Instead, it was a real attempt to engage with international law. And despite confirming that Section 67 was all about a rehearing, he made repeated recourse to the tribunal's reasoning. Similarly, in the second case, Mr. Justice Butcher in Korea and Dayani also adopted that approach. Now, this was another eminent tribunal headed by Bernard Hanoshio, and in that case, they found that they did have a broad jurisdiction. The argument was raised by the Republic when they received an unfavourable award that there were multiple bases on which to set it aside. Essentially, there were arguments about the meaning of investments, the meaning of investor, and they ran a rather ambitious argument based on attribution, saying that none of the acts were attributable to the Republic and therefore there was no jurisdiction over them, which frankly I find slightly difficult to understand as a jurisdictional point. But nonetheless, once again, we see the court engaging in a really rigorous analysis of the issues by reference to the wording of the BIT, many investment arbitral awards, and also sort of authorities such as commentaries, textbooks, etc. So I think one sees a parallel between those two cases, even though Mr. Justice Butcher upheld the tribunal's award effectively. It's the same sort of thought process. So what about the third case where things became more controversial? So this is a very recent decision, the end of 2021, by Mr. Justice Andrew Baker, former member of my chambers. And this has caused a lot of controversy. The name of the case is Goldpool and Kazakhstan. It's one of a few cases that have considered the impact of the breakdown of the USSR on investment treaties, and in particular whether Kazakhstan was a successor of the USSR Canada BIT. So that was really the only issue before the court, this question of succession. The arbitral tribunal, which again involved David Williams, so another experience for him before the English courts, decided there was no jurisdiction. Now, Andrew Baker says that that was wrong. And in circumstances where all he was considering was this issue of whether or not there was a tacit agreement amounting to succession under the BIT, it was quite interesting to see the way in which he approached it. Quite notably, which I think a lot of people have picked up in the blogs and other places, there was no reference really to international law at all. What he focused on were the relevant events that were said to constitute this sort of tacit agreement. And by that, he was referring to words and conduct on both sides that could be said to give rise to this intention to continue the relevant BIT. Quite interestingly, I think, for a case of this kind, this was an extempore judgment. So he was so confident in his position that he felt willing to deliver that judgment orally. He didn't go away and think about it and produce a long judgment. Instead, it was a long extempore judgment. Second of all, this case was entirely in the public domain. Now, these claims are normally heard in private, and then one has a fight at the end of the process as to whether or not the judgment should be public. But here it was all in public. And again, as I say, there is this tension in terms of approach, no real engagement with international law in the same way. So in conclusion, to return to the question I posed at the outset, are the English courts averse to applying principles of public international law and instead revert to sort of common law principles, which in my experience is a sort of common perception in these kinds of cases? My view is no, for two reasons. First of all, the two judgments that I discussed at the outset demonstrate that the courts are entirely comfortable with these issues when they're presented sort of fully and completely with the relevant authorities. Second, and this might be a more controversial position, but I think it's very arguable that Mr. Justice Andrew Baker's approach in the last case we discussed was very much as a result of the way in which it was presented to him and the particular question he had to decide. There was common ground between the parties as to what the law was. He was then considering whether or not the facts gave rise to a tacit agreement for the purpose of secession. Now, in doing so, he had to consider the meaning of recitals and particular memoranda between the two states, and arguably he could have been a bit assisted by the relevant treaty interpretation principles, for example, and he didn't give reference to them. But I think it's a little bit unfair to paint the picture, as some have done, that this judgment shows some sort of aversion to applying principles of public international law. If anything, the slight difference of approach between the first two judges on the one hand and Mr. Justice Andrew Baker might be explained by a small nuance in the way in which they consider the value of arbitral tribunal awards. Now, they all recognise that a Section 67 hearing is a rehearing, a de novo hearing, as I mentioned before. What that means is they all had to decide the question of jurisdiction very much for themselves. But Mr. Justice Butcher expressly recognised in his judgment that he felt that the tribunal's conclusions were of interest, and if and to the extent, and I quote, that the reasoning is persuasive, then there is no reason why the court should not be persuaded by it. However, in the last judgment, Mr. Justice Andrew Baker slightly bridled at this idea. He said, this idea needs to be applied with a degree of caution. The court's task is to decide the cases presented to it by a party on the rehearing, and it's to the parties themselves to decide on the arguments or evidence that they wish to adopt from the previous arbitration process. And this perhaps slight difference of approach is demonstrated in the way in which they engage with the tribunal's decision. It's quite notable that Mr. Justice Andrew Baker's judgment, right at the end, paragraph 112, I think it is, had a few sort of cursory references to why the tribunal's reasoning was wrong, whereas for the other two judges, it was very much the foundation of their reasoning, tribunal said this, however, I think this, or I entirely agree, let me add X, Y, Z. So I would conclude by saying I certainly think that there is perhaps a little bit of nuance in the different approaches that were taken in these judgments, but one can't simply say at all, as is often said, that the English courts do not have a sophisticated appreciation of and high regard for public international law. And one just has to look at the recent diet of cases before the Supreme Court to see that proposition manifested. So I hope that has been of some interest to those of you who haven't come across Section 67 before, and look forward to discussing it a little bit with you later if you've got any questions. Thank you very much. Sorry.
Thanks very much, Belinda.
Sorry. Dramatic end.
It was
Throw a
very
glass.
dramatic.
Sorry.
And it was
Thanks.
great to hear that after hearing the opposite of you in the Paris story. So thank you very much for that. We now have Alvaro Nistal speaking. Alvaro is going to speak about investment protection in light of the recent invasion in Ukraine. Alvaro, over to you.
Thank you. I should know that I had already spilled over a whole glass of water on my own notes. So this is actually good.
A very dramatic morning.
I'm glad it's up to speak.
Thank you, Mia, for the introduction, and thank you to the organizing committee for having me in this very interesting panel. As everyone in this room knows, in the early hours of 24th February, Russia launched a large-scale invasion of Ukraine, and this sparked one of the biggest wars on European states since the Second World War. So, in light of this situation, foreign investors in Eastern Europe and states in that region are eager to know more about what are their rights and legal obligations in relation to the protection of foreign investments during an armed conflict. And the answer to that question depends on a wide range of legal and factual considerations. That said, and without pretending to be exhaustive, I will try to share 7 of those considerations, which I think are key to have at least a roadmap of what are the key legal issues to take into account. The first consideration is that the existence of an armed conflict does not automatically terminate or suspend investment treaties. The ILC draft articles on the effects of armed conflicts on treaties provide a series of examples of factors that should be taken into account when deciding whether or not a treaty is susceptible to suspension or termination as a result of an armed conflict. And the factors that are mentioned in the ILC draft articles revolve essentially around the nature of the treaty and the intensity and scale of the armed conflict. As you can imagine, the more intense the conflict is, the more territory it covers, the more likely it is that it could provide the basis for suspension or termination of a treaty. In terms of the nature of the treaty, well, it's obvious that treaties that in the first place were conceived to apply in armed conflicts will not be suspended because of an armed conflict. So you're thinking there about IHL treaties, but also human rights treaties. The treaties concerning the resolution of disputes also would not be suspended. Now, the ILC provided a list as part of the annex to its draft articles of the kind of treaties that would not be suspended. And based on that list, I think it's fair to say that investment treaties are connected to at least some of the points there, and the list obviously is not exhaustive. So we have there, first consideration, automatically they are not suspended. Second, the indications given by the ILC suggest that investment treaties are probably not in the categories of treaties susceptible to be suspended. But in addition to that, and regardless of these points, what's clear is that in order to be suspended, the state seeking suspension would need to follow certain procedures. It would need to send a notification. It would need to take certain steps. And this is reflected both in the VCLT and in the draft articles on the effects of armed conflicts. So at the very minimum, we can say that in the absence of a notification, in the absence of those formalities, there is a strong presumption in favor of continuity of investment treaties during armed conflict. The second consideration is that, as the ILC draft articles themselves say, when a treaty contains a provision that is supposed to apply in an armed conflict, well, obviously that provision will apply during the armed conflict. And in the context of investment treaties, there are a number of provisions that fall within that category. For example, clauses for compensation for losses. These clauses seek precisely to ensure compensation in the event of hostilities, war, or similar situations. For example, full protection and security, which certainly covers damages suffered as a result of physical attacks on the investment. To a certain extent, you could say even dispute resolution clauses. So that's the second consideration. Certain provisions will certainly, well, perhaps not certainly, will probably continue to apply during an armed conflict, regardless of the scale of the armed conflict. And this takes me to my third consideration. So when analyzing the rights and obligations of investors and states in the context of an armed conflict in relation to the protection of foreign investors, one should therefore turn to investment treaties in the first place. And I guess it's fair to say that the first set of treaties that one should analyze is the treaties concluded between the host state of the investment and the home state of that investment. And although this is obvious, you will see when I come to a following consideration that it is not the only possible set of investment treaties that you can look at. So obviously you need to check that the foreign investor and the investment qualify as such under the relevant treaties. But that's not the only issue that you should look at this initial step. One should also analyze whether the treaty or treaties in question contain so-called treaty exception clauses. These clauses exclude from the scope of application of part or the entirety of the investment treaty measures taken by the contracting states to fulfill their obligations related to national interests. Some of these clauses exclude measures taken in the context of national emergencies. And arguably, the conditions to meet the requirements of a security clause would be easily met in the context of an armed conflict like the one we are seeing in Ukraine. If the relevant treaty contains one of these national security exception clauses, one will need to consider multiple complex legal issues regarding the interpretation and application of the clause, but also the nature, objective, and effects of the measure at stake, the measure that is being challenged. For example, a number of treaty exception clauses require that the state measure not be applied in an arbitrary manner and do not constitute a disguised restriction on foreign investments. By contrast, other treaty exception clauses do not impose such limits, and self-judging provisions even provide wide discretion to the home state, well, to both contracting parties, but in the context of the dispute, to the home state, to decide whether or not its measures were taken for national interest, to secure national security, and therefore, essentially, these clauses give wide discretion to the state to decide whether its actions fall or not within this category, this exception set out in the security clause. Fourth, one should also consider whether the state measure is likely to constitute a breach of a substantive provision of the relevant treaties. Clauses concerning compensation for losses and full protection and security are likely to be relevant to damage suffered by foreign investments during an armed conflict. The most Common clauses on compensation for losses essentially provide for national and most favored treatment in relation to compensation for damages caused during an armed conflict. So essentially what they do is, if, let's say, if Ukraine, for example, were to offer compensation only to a certain category of foreign investors that have suffered damages and not to another category, another nationality, well, that could potentially constitute a violation of this kind of compensation for clauses, for losses clauses. But if Ukraine were not to issue, to award any compensation, well, then a foreign investor would not be entitled to claim compensation from Ukraine. It's just a non-discrimination standard. By the way, I've used Ukraine, but I'm not basing this on any specific BAT of Ukraine. I'm just trying to explain what is the rationale of these non-discrimination clauses concerning compensation for losses. So-called extended compensation for losses provisions also require the host state to provide restitution or adequate compensation to protected investors, but only for losses resulting from the requisition of their investment by the host state. This would not cover losses caused by the armed forces of the invading state. Often, the obligation to pay compensation under these broader clauses, that, as I said, are often called extended compensation clauses, also applies to destruction of investments by the host state, but only provided that the destruction is not caused in combat action or required by the necessity of the situation. And in practice, these types of clauses impose a high threshold on the investor. It is often very difficult to prove that the damages suffered by an investment during an armed conflict have been caused by the armed forces of the host state and not by other parties to the hostilities. And it is equally challenging to prove that the damages were not caused in combat action or required by the necessity of the situation. So we see that even these extended clauses provide requirements that are difficult to meet and that can be significantly challenging for foreign investors. The investor could potentially try to overcome some of these obstacles by invoking a most favored nation clause of the treaty, and the idea would be to import into that treaty more favorable clauses concerning compensation for losses during an armed conflict that are contained in other investment treaties. And there are a few compensation for losses clauses that require to pay compensation regardless of which state or which party to the conflict caused the damage. So one way to overcome the obstacles that I mentioned before would be relying on the applicable or multiple applicable BITs, finding an MFN clause and relying on that to import a more favorable compensation for losses clause from another treaty. As I mentioned earlier, a treaty's full protection and security provision is also likely to be relevant to damages suffered by a foreign investment during an armed conflict. As multiple tribunals have confirmed, in the context of an armed conflict, FPS clauses essentially require the host state to take reasonable measures to protect the investment from the host state's own military operations and from the actions of other parties to the hostilities. However, a foreign investor is unlikely to be entitled to be paid compensation for damages that the host state would not have been reasonably expected or able to prevent. And an overwhelming attack by another state will probably lower significantly the level of due diligence and the protection expected from the host state under an FPS clause. The same applies to other traditional standards of protection. An action taken by a state during an armed conflict could breach one or more of those standards, including protections against unlawful expropriations and unfair and inequitable treatment. However, the specific circumstances in which the relevant state measures are being implemented and the apparent objective of those measures might be key when determining whether or not they constitute a breach of those standards of protection. The respondent state would likely rely on a number of principles or doctrines of international law in order to defend measures that, in peacetime, might indeed constitute a breach of the applicable treaty. For instance, states would likely rely on the doctrine of police powers. Based on that doctrine, multiple tribunals have found that the state's reasonable bona fide exercise of police powers in matters concerning national security excludes compensation, even when the state actions cause economic damage to the investor. In addition, the host state might argue that tribunals should pay great deference to governmental assessment of national needs during grave crisis. And there are authorities supporting that view. The award in Continental against Argentina is a pertinent example. In determining whether Argentina's measures actually sought to protect essential security interests, the tribunal found that the significant margin of appreciation is due to the state applying the particular measure. Of course, that case didn't concern an armed conflict, but the tribunal said something that I think could apply and can be extrapolated. In its words, it said, a time of grave crisis is not the time for nice judgment, particularly when analyzed by others with the disadvantage of hindsight. So essentially there, what the tribunal is saying, you cannot 2, 3, 4 years after the conflict claim that the state got it wrong and should have taken a slightly different decision because you need to give some deference to the tribunal, to the state that was in a particularly difficult situation and did what it could with the resources available. I now turn to a fifth consideration. In certain circumstances, foreign investors may also be able to seek compensation from the state that invades the host state. And indeed, we know that more than 10 sets of investors operating in Crimea have chosen to initiate investor-state arbitrations not against Ukraine, but against Russia. It seems that none of the awards issued today in those arbitrations is fully public yet. However, based on commentary and the decisions of local enforcement courts, we know that all or virtually all of the tribunals have concluded that for the purposes of the Ukraine-Russia BIT, Crimea should be considered part of Russia's territory. On that basis, these tribunals have asserted jurisdiction over claims concerning actions taken by Russia against foreign investments in Crimea. Apparently, these tribunals base their decisions primarily on the fact that at the time of the alleged violation, alleged treaty violation, Russia had de facto control over Crimea. However, one should probably be careful when extrapolating this conclusion to investment disputes concerning other areas of Ukraine or entirely different armed conflicts. The situation in Crimea is sui generis for multiple reasons. For example, it is undisputable that Russia claims to have formally annexed Crimea to its territory. This has not happened yet with other regions of Crimea, of Ukraine, and is also rather unusual in recent armed conflicts. Another peculiarity of the Crimean cases is that all or virtually all seem to be based on the Ukraine-Russia BIT. Therefore, as some of the relevant tribunals have noted, it is clear that this treaty, the Russia-Ukraine BIT, applied to Crimea in one way or another. And based on that intuitive idea, one tribunal noted that the armed conflict between Ukraine and Russia simply could not have the effect of excluding Crimea from the geographical scope of the BIT. We do not know what the decision of the tribunals would have been had the investors based their claim on other Russian investment treaties. For example, there is no BIT between Latvia and Russia. So if Russia were to invade Latvia and a foreign investor seeking compensation from Russia would need to rely on a different investment treaty. Arguably, unlike in the situation in Crimea, originally that BIT was not supposed to cover Latvian territory invaded by Russia. So the question is, in that circumstance, would de facto control over that region by Russia be enough to bring the claim within the geographical scope of the BIT? A sixth group of legal and factual considerations concerns a range of customary international law defenses codified in the ILC articles on state responsibility. States faced with claims for compensation for damages caused during armed conflict would likely invoke defenses such as necessity, force majeure, or even distress. Each of these defenses sets a high threshold. However, if successful, they would operate to preclude the wrongfulness of state measures that are contrary to international investment protections. Put differently, it is possible that an investment treaty does apply to a measure implemented in the context of an armed conflict, that the measure is indeed contrary to that treaty, and yet, despite all of these, that the measure does not trigger international liability because the state successfully invokes one or more of the existing customary international law defenses. Seventh, and to conclude, foreign investors also may be able to obtain compensation for damages suffered during armed conflict in other fora, including public international law courts. While this is a possibility in the context of the present and other armed conflicts involving Russia, there are a series of important challenges that must be borne in mind. For example, following Russia's recent withdrawal from the European Convention on Human Rights, the European Court of Human Rights will remain competent to deal with applications directed against Russia only in relation to acts or omissions that occur no later than 16 September 2022. Beyond that time frame, there might not be any obvious jurisdictional basis for an investor to seek compensation from Russia before a public international law court. Further, other public international law avenues often require that the home state of the claimant party espouses its claims. And in that situation, the state does not have an obligation to transfer to the investor any compensation obtained during the proceedings. Public international law avenues might also require that the claimant first exhaust local remedies before the national courts of the respondent state. And these courts might not be impartial or free from political and legal pressure when it comes to assessing the lawfulness of their own state's actions in the context of an armed conflict. Pure public international law proceedings also are often lengthier than investor-state arbitrations, and they tend to lead to monetary compensation that is lower than that granted in investor-state awards. Finally, public international law avenues do not always guarantee an effective mechanism for the enforcement of the resulting decisions. This concludes my presentation. I would be happy to discuss any comments, and I thank you for your attention.
Thanks very much, Alvaro.
Thank you, Miff. I thought for a moment there you were going to suggest that I was going to be the one to pay for it, just for the avoidance of doubt. No. So thank you very much, everyone. We're familiar with questions of access to justice in a range of legal fora. We know about the right to a fair trial, which is being recognised as a fundamental right in international courts and tribunals and regional courts and tribunals and domestic courts and tribunals. We're seeing increasingly that claims are being brought in this jurisdiction for alleged environmental damage, which has occurred overseas. And that's in part because the Supreme Court has recognised that the claimants would not have access to justice but for the claims being commenced in this jurisdiction. We've also seen in the commercial courts regular pushing of the boundaries of things like conditional fee agreements or the rule against champati. So we're seeing access to justice issues come up all of the time. And what I want to suggest this morning is we need to do a little bit more careful thinking about access to justice in the context of investor-state arbitration. Now, I'm convinced there's a PhD topic in here somewhere, and I've got no doubt we've got the people in the room to do some careful thinking about this. But in addition to the academic way of looking at this, I would also urge the practitioners in this room to have a careful think about what we can be doing in order to increase access to justice for our clients, and also what opportunities that might create, and indeed, is there a professional obligation upon us as practitioners to be doing more to give our clients access to justice. We know that as a matter of international law, everyone has the right to own property alone and in association with others, and that nobody shall be arbitrarily deprived of their property. We know that everybody has the right to a remedy for when there are breaches of these rights. And we know that when the property in question is located on foreign soil, we have a regime through the investor-state dispute settlement regime, which is capable of providing redress for victims in those circumstances. So far, so good. We've got the right to property, we've got a right to a remedy, and we've got an established and sophisticated set of rules and procedures which offer our clients the opportunity to pursue their legal rights. So what's the problem here? What's the legal obstacle stopping our clients from getting remedies from time to time? Well, a UN study published about 18 months ago recently recognised that one of the most significant obstacles in accessing justice in the investor-state dispute area is the cost of legal advice and representation. And when we're talking about costs, obviously it's the cost of solicitors and barristers. It's the institutional costs like ICSID or UNCITRAL, for example. It's the tribunal costs. It's expert fees. It's travel expenses. It's disclosure platforms. These things become really quite expensive. And there was another recent study not so long ago conducted by the Corporate Council of the International Arbitration Group, which found that 100% of corporate counsel considered international arbitration to be too expensive. 100%. And most of that criticism was directed specifically against investor-state arbitration. Now, know what you'll say. Of course, general counsel are going to say that their lawyers are too expensive. So I would rebut that by saying, when have you ever heard general counsel agree unanimously on anything? So 100% of the general counsel of our clients are telling us we're too expensive. How expensive are we? Is there any empirical data which gives us an indication on this? Well, there was a Bickel study published last year which gives us a bit of a clue into how long these arbitrations are running and how expensive they are. And what that found was that, first of all, investor-state arbitrations are taking longer. They're long, but they're taking longer. An average arbitration now, an ICSID arbitration, will take 4 years and 8 months to complete. And by complete, I mean get to a final award. That's before you start thinking about annulment proceedings and before you start thinking about perhaps a Section 67 challenge and before you start to think about enforcement. If the claim is over $1 billion US, then you're looking at more like 8 years from start to finish. And again, before you think about annulment and enforcement and so on. The same study found that claimants are paying 20% more for these cases than they were 3 years ago. So how much are they actually paying? Here's a bit of an indication. So the two figures we've highlighted there, so we've got ICSID in the middle and we've got UNCITRAL at the end. The purple bar is what it costs for an investor to bring these claims. So the average cost for an investor to bring an investor-state arbitration, $7.2 million US if you're doing it under ICSID, and 5.2 if you're doing it under UNCITRAL. I emphasise that's the average cost. Some are significantly greater than that. I had a case come across my desk recently where another firm that shall remain nameless had costed the arbitration from start to finish at $24 million. There is some good news, however, in the Bickel study, and that is that tribunals are ordering greater sums of damages, and they're more willing to award claimants more than they ever have in the past. In fact, it's gone up 184% over the past 3 years. Here's an indication of that. Again, so as a caveat, we exclude UCOS from all of this because that is just a complete outlier that it just messes up all the statistics if we start to include that. But if we exclude UCOS, in the middle we see there that the average amount of damages awarded to successful claimants was about $111 million up until June 2017. In the last 3 years, though, that's gone up to about $315 million. So these investor-state arbitrations are longer, they're more expensive, but tribunals are more willing to award greater sums in damages. And what I would suggest is this is creating a real access to justice gap. Because even for a well-resourced claimant, it's going to be difficult to obtain board approval for $7 million in legal spend when the board might well say, well, if we do that, that's another city that we can't open office up in, or that's a project that we cannot invest in, or we need to give our employees a pay cut across the board. So even well-resourced clients are struggling to come up with this money. But the real issue, of course, is for the impecunious claimants, typically those who have had their entire investment expropriated by the respondent state. Or perhaps because of the respondent state's actions, the value of the investment has diminished significantly. These are the claimants who are really struggling to fund these cases, and we need to come up with solutions. Now, if we're talking about $5, $6, $7 million in funding, you could start a GoFundMe page, I guess. Probably not going to get very far. So there's one obvious solution. We're all thinking about it. So to get it out of the way, the obvious solution for how to fund these cases is cryptocurrency. So, and I kid you not, this is absolutely true. It's not one day late for an April Fool's joke. So this was reported in GAR a few days ago. We have a US entity that announced that it was looking to raise funding for a $13 billion claim against Slovakia by launching its own cryptocurrency. So we've all got this opportunity today. By purchasing this coin, you can own, quote unquote, fractional ownership of up to 80% of the final award. Insert all the usual disclaimers here about this is not financial advice. Value of your investment may go down as well as up. I'm not suggesting you do this, but the option is out there, right? So if we're excluding GoFundMe, and if we're thinking that this might be a bit beyond our risk appetite, how does a claimant fund these claims? And of course, the real obvious answer is third-party funding. And third-party funders, as you might imagine, given that we're seeing that the value of awards is going up at an extremely high rate, third-party funders are getting really interested in this area. And the market is booming. Here we see that there was a report that the UK third-party funding market is worth about £2 billion. That's the UK alone. We expand that further to the global market, that's estimated to be around $13 billion. So $13 billion that investors have invested to fund these claims. How does a third-party funder go about approaching these opportunities? They're not going to invest in everything. One rule of thumb that they tend to apply is that they typically work on what's called a 10-to-1 ratio. And what that means is that they will look at the expected legal spend and the expected amount to be recovered and try to ensure that the expected recovery is 10 times more than the legal spend. So I want you to keep that figure in mind because I'll return to it later in my closing observations. How do we go about getting third-party funding? Well, the first step is often you'll need counsel opinion. So I'll pick up the phone to Belinda and say, look, we've got this really exciting case, investors struggling to fund it. Can you give us a merit advice on prospects of success? And she will produce a merit advice that we waive in front of the third-party funder. You'll typically need a quantum expert to verify the numbers of your claim, to make sure that it's going to really recover as much as your client is telling you it is. You'll need a well-thought-through costs budget, which takes you from start to finish, and the third-party funder begins to think about how much it's going to cost them. But the third-party funder is also going to be interested in a number of other questions, which touch upon the issues from the excellent presentations we've heard today from my co-panellists. So returning to what Kate spoke about earlier, an investor is going to want to know, well, what's the prospect of there being a challenge on Achema grounds? If there is, how likely is that to succeed? You heard Belinda speak about Section 67 challenges. So if our client manages to survive a jurisdictional challenge before the arbitral tribunal, how likely is it that there's going to be a second bite of the cherry for the respondent? And how long is that going to take, and how much is that going to cost? Belinda spoke about GPF in Poland as an example. So I'm very pleased to hear that Belinda said she had some sympathy for that judgment. I acted on that case a few years ago, and I can tell you that the timeline between when we received the award on jurisdiction and when we actually received the judgment was about 13 months. So that's an extra 13 months that a funder is going to have its money tied up in this investment, in addition to the 4, 5, 6, 7, 8 years that it's going to be tied up for the actual arbitration itself. So a funder is going to want to know those sorts of questions. Going back to Alvaro's presentation that you heard a moment ago, how easy is it going to be to enforce any judgment against a respondent state? Russia, for example, has 63 BITs in force. And needless to say, myself and colleagues and others are fielding numerous claims about potential investment treaty claims under Russian BITs. But in the current circumstances, funders, I think it's fair to say, showing great reluctance, extreme caution to fund cases, knowing that they're one day potentially going to have to enforce against the Russian Federation. So it looks like third-party funding might be the way to go. And it's very much a case of watch this space in the investment treaty arbitration arena. But what we're seeing as well is an increasing regulation of third-party funding. So you may have seen a couple of weeks ago, we saw some new ICSID rules announced. They're going to come into force in July. And basically what they're requiring now for third-party funding, it's a new Rule 14, requires that there be disclosure of the existence of third-party funding and the name of the funder. And that's being designed to avoid potential conflicts which may arise, for example, between the arbitrators on the one hand and the third-party funder on the other, if there's some relationship between the two. So commencing an ICSID claim after July, you'll need to disclose if you have any third-party funding and also the name of the funder. But you don't need to provide, at least at this stage, the terms of that funding that are in place. The respondent state might request details of that, but that's within the discretion of the tribunal as to whether they order that based on whether it's relevant to an issue in dispute between the parties. But in addition, the arbitrators are now required to disclose, to declare that they have no conflicts with any of the parties acting on the matter, but also no conflicts with any of the third-party funders who are engaged. So that's the amendment to the ICSID rules, which will be coming in shortly. UNCITRAL are also looking at this through a working group, and they may even go further and potentially ban third-party funding. So the reason for this is because the working group has identified that there are recent investment treaty cases in which claimants have succeeded despite there being findings against the claimants that they inflamed tensions and violence with Indigenous communities, had inadequate environmental authorisations, were engaged in fraud or were engaged in corruption. And nevertheless, these claimants are getting awards in their favour with damages being awarded in their favour. And the UNCITRAL working group has identified that those cases all have a common denominator, and that is that they're all receiving third-party funding. So the second paragraph there, they say, notably all of these claimants and their problematic claims were financed by third-party funders. And they go on to suggest that the existence of third-party funding in this space it encourages marginal, speculative and high-stakes claims that even when unsuccessful are still very costly to respondents. So there is a proposal which has been published. It's now open for comment and will remain open for comment until the 30th of July. And then it will likely be the case that we'll see some new UNCITRAL rules, and all options are on the table, including potentially the possibility of banning third-party funding in investment treaty arbitration. By way of conclusion, what does that mean for third-party funding? Because I said earlier, there are already access to justice gaps, and if third-party funding is banned, there'll be even greater access to justice gaps. I said earlier about the 10-to-1 ratio and how I'd be returning to that. We identified that the average cost of these arbitration is somewhere in the region of $7 million. Now, if a third-party funder is looking at that and working on a 10-to-1 ratio, that would suggest that a third-party funder would not be interested in funding any claim which is less than, say, $70 million. So for those claimants, third-party funding is simply not likely to be an option. What does that mean, and what can we be doing, or what should we be doing about that? And I would leave you with that thought that do we, as legal professionals, have a professional and moral duty to be representing these underrepresented claimants in these claims? And if it's the case that our traditional business model does not allow these unrepresented claimants to access justice, is it incumbent upon us to, as a profession, to change that model? Should we be looking into more conditional fee agreements as lawyers? Should we be looking at fixed fees or capped fees? And so I'll leave you with that thought and encourage everyone in this room and also the budding PhD students to reflect upon what more we can do as professionals to ensure that all claimants have access to justice under international law. Thank you.